Hi, I'm attorney Eric Lewis with Lewis Legal Services in Indianapolis. Today we're talking about the not-so-fun topic of wage garnishments. Before we get started, I always start with the disclaimer that this video is not legal advice and is only intended for Indiana residents, of course tailored to the application of bankruptcy in Indiana courts utilizing Indiana laws. Okay, that out of the way, if you've had the misfortune of suffering through a wage garnishment, you probably know what it means to have a chunk of your paycheck taken each and every pay period. What I want to talk about here is how it works and what you can do to stop it. So a wage garnishment is the result of a lawsuit judgment being entered against a defendant. In some cases, like with defaulted student loans, for example, the law allows for administrative wage garnishments that don't require a lawsuit. And of course, there are wage assignments and garnishments for things like child support. What I want to concentrate on today is a wage garnishment that is the result of what we call a money judgment. So you lose a lawsuit and now you have to pay money. And in Indiana, the law allows the plaintiff, also known as the judgment creditor, to attach and seize a portion of wages of the judgment debtor. That is, of course, the person owing the money on the judgment. That happens at what is called a motion for proceedings supplemental to execution, what's also known as a pro-sup. The court will set a hearing to determine what non-exempt property can be taken to help satisfy the outstanding judgment. And the most common non-exempt property are wages from work. So they'll send what are called interrogatories to your employer. Of course, if they know where you work, then they'll ask the employer to confirm the details of your employment. The employer has to either return answers or appear in court. And once the court gets the answers back, the judge will issue a court order instructing the employer's payroll to withhold a certain percentage of wages. In most cases, that is going to be 25% of your net wages after allowing for the deduction of taxes and Social Security. The amount of your paycheck that is guaranteed to be protected from these type of wage garnishments is the amount that's equal to 30 times the federal minimum hourly wage. So right now, the minimum wage is $7.25. So 30 times $7.25 is $217.50 per week. So earnings above that amount are fair game for them to take in satisfaction of the judgment. And in some cases, the judgment debtor can try to convince the judge to lower the garnishment amount to something lower than 25%. But under no circumstances can the judge go less than 10% because the law dictates that 10% is the absolute minimum. So if you have a wage garnishment and, of course, from a money judgment, what can you do about it? Well, you can try to work out an alternative payment arrangement directly with the plaintiff's lawyer. But that can often be difficult because they don't have much incentive to work with someone on promised payments when they can get guaranteed payments, of course, that are typically 25% of every paycheck. So you may also consider filing for bankruptcy protection, of course, if your overall financial condition warrants it. The filing of a bankruptcy petition creates what's called an automatic stay against collection, and that stay immediately stops further wage garnishment. Now, bankruptcy can stop the garnishment, but it doesn't recover the money already taken. So sometimes I'll get clients who have researched things online and think that they can get the garnished money back if they file bankruptcy. Even some attorneys are confused on this issue because in some states, a debtor in bankruptcy can get back, most or if not all of their wages that were garnished by filing bankruptcy and claiming those wages exempt. And that, of course, is only if the trustee appointed to the case isn't interested in the money because maybe it's just not enough. But however, that is not the case in Indiana. In Indiana, filing bankruptcy only stops the garnishment. We can't recover funds that were already garnished before the filing of the bankruptcy because there is no exemption under Indiana law or current Indiana law to cover them. So many people do in fact file bankruptcy when they have a garnishment because when you have a judgment against you for a broken lease or a repoed car and it's like $8,000 or $10,000 or $15,000, that is a lot of money out of each and every paycheck to pay off the debt over what would be years to pay. So if you have a wage garnishment and your wages are garnished after you file bankruptcy, you can get that money back. But you can't get back money that was garnished before your bankruptcy was filed. That money is gone. So that's it for today. I hope this video was informative. For more information, contact my office. If you liked this video, click like, click subscribe for further notifications. And as always, thanks for watching.